Welcome to the DeFi Standard. This is Patty XRP, and today we are going to get everybody caught up on the flurry of information that has come in the SEC versus Ripple Labs case, determining whether XRP is a security from its origination through present day. Obviously, a lot of us in the XRP community don't feel this way, but our opinions don't matter as much. And we have this ongoing court case with a hearing that was held last Thursday. And in this hearing, we found out that the Ripple team and their lawyers are going to be able to depose Bill Hinman, the former director of corporate finance at the SEC, and who, I would say infamously gave the Ether is not a security speech that many people thought was an official position of the SEC, even though to this day the SEC still denies that and says that it only has to do with the personal opinions of Bill Hinman. But in that speech, he uses the words we a lot. We've seen a lot of people throughout the industry take that as guidance. And so the Ripple team really needs the ability to, figure out what was going on with that entire speech. We know one of the Ripple lawyers brought up in the call that Bill Hinman had been meeting with the Ethereum Foundation as well as the team there. So we don't know if that would include the likes of Vitalik Buterin to that height, but he was definitely in talks with those deeply involved with Ethereum. We also know his law firm is on the payroll of the Ethereum Alliance, and he was receiving funds from his law firm, I believe, in the form of pension payments during his time at the SEC. So, not a lot of great optics around that. And, Ripple needs to be able to barrel down on what was going there and, figure out, let's say, why was Ethereum singled out? What level of decentralization did Ethereum actually have to warrant this speech? And is that comparable to XRP? And, while some of those things may not seem the most important, they definitely can help with the fair notice defense for Ripple, as well as Brad Garlinghouse and Chris Larson. And the reason I say that is, if Bill Hinman can kind of point to how people are unsure about the clarity of these assets, and that could have to do with XRP during the time of his speech, then I really think that could help with, saying, how could Ripple have known this all along if the SEC didn't know it? And, did Bill Hinman get help from, any parties at the SEC? Did he talk to Jay Clayton about this? Did he talk to Hester Peirce? Did he talk to Elad Roisman? Any of those people? Did they have opinions on, XRP or Ether at the time? And we also found out that the SEC has still not delivered any documents around internal conversations that are being allowed by Judge Sarah Netburn in the discovery phase, having to do with Bitcoin, Ether, and XRP. So they're still waiting on that stuff. And it seems like, with this deposition going through, that the SEC was really trying to fight this tooth or nail, saying they would object to everything. However, John Deaton went on a video with Tony from Thinking Crypto earlier today and kind of gives a bunch of reasons why he doesn't think that Hinman will try and skirt around every question out there or even plead the fifth, as that could imply guilt and also warrant some kind of inspector general investigation into the SEC and what was going on with this case being filed, as Jay Clayton's leaving out one door, and then we have the enforcement director also leaving shortly after as well. So, a lot of weird things, as many are aware at this point, going on. But I would now like to turn this over to some new developments that just came out today. And you can see on our screen here that we have the lawyers for Brad Garlinghouse and Chris Larson writing to Judge Annalisa Torres, who is the main judge over this case. Judge Sarah Netburn is just residing over the discovery phase. However, we can assume that they work together and talk about it, what's going on throughout this entire case. They're not completely siloed from one another. And so here, we're getting an exhibit from two of the SEC commissioners, Hester Peirce and Elad Roisman, who we kind of know have been proponents for the crypto industry in the past, and they had a public statement a little less than a week ago on July 14th in regards to a case that was just settled with a firm called CoinSchedule. So CoinSchedule was getting paid to list tokens on their platform so people could see like, ongoing ICOs and all that stuff. However, they failed to state which of the coins on their websites are securities and are now getting fined for it since they took payments and didn't do the correct disclosure methods. And what they want to say here basically is that the public statement from Elad Roisman and Hester Peirce supports the individual defendant's motion to dismiss for failure to adequately plead that they allegedly aided and abetted Ripple's offers or sales of unregistered securities. And one thing to take into account here is with Brad Garlinghouse and Chris Larson also having a case brought against them for aiding and abetting in Ripple's sales of unregistered securities. It's not enough for them just to have like, been like, oh yeah, we can sell right now. They had to know and, beyond a reasonable doubt, know that what we're doing is wrong and selling up securities. So like the bar to charge these two when Ripple Labs is, an incorporated firm is much higher. And so, they're just adding to their motion to get out of this. So some of the important things from this speech, or not necessarily speech, but letter that was put out by Roisman and Peirce, basically says the SEC approved a settlement concerning the respondent's promotion of securities without disclosing compensation. So this is CoinSchedule. And then in a public statement following this resolution, which included Hester Peirce and Elad Roisman, they are two of the five sitting commissioners of the SEC. And the plaintiff in this action criticized the SEC's failure to explain which of those digital assets touted by CoinSchedule were securities, an omission which is symptomatic of our reluctance to provide additional guidance about how to determine whether a token is being sold as part of a securities offering or which tokens are securities. So that's a quote directly from Parson Roisman's letter, and they are saying that the fact that they couldn't explain which of the digital assets that CoinSchedule put on their website and was promoting were securities, and that's symptomatic of that agency's reluctance to provide any additional guidance about how to determine whether a token is being sold as part of securities offering. So, like, I mean, to me, that's a huge deal and a huge admission by two of the sitting commissioners that were sitting as well at the time that this case was dropped. And, they're just straight up saying the SEC is not being clear about any of this, and they continue to not be clear. So, what I ask is, how was there fair notice for Ripple Labs, for Chris Larson, for Brad Garlinghouse? To me, like, this admission is just a huge gift. I've seen like Jeremy Hogan on Twitter say as much as well that, this is really great for Ripple Labs. And I feel like he's been pretty objective. He's definitely said when he thinks things aren't going to go the way of the Ripple team and all that stuff. So I kind of appreciate what he's been able to give out to the community in that regard. And so let's just touch on a few other statements from this letter. Basically, Peirce and Roisman observed while they've been at the SEC, the only certainty we see is that people have questions about how to comply with the applicable laws and regulations. That's the only certainty that they've seen. I mean, that's pretty crazy. There's no certainties around, what kind of guidance or clarity that the SEC has put out, which is basically zilch. And even that Ether speech, which is supposed to be one of the, hallmarks for clarity that's come out, is still rather unclear. Additionally, they said there is a decided lack of clarity for market participants around the applications of the securities laws to digital assets and their trading. With respect to many digital assets, the application of the Howey test is not crystal clear. Yeah, definitely agree with that one. I think a lot of us have been saying that for a while. How are we going to take some, rule or I guess court ruling about the Howey test that came through back, I want to say, in the 1940s. It's about close to 80 years since that thing came out, and there's been a lot of changes in technology and what is the meaning of raising funds, especially in a decentralized nature, versus a centralized one. And then also they go on to say, although the commission staff has provided some guidance, the large number of factors and absence of weighting to cut against the clarity the guidance was intended to offer. Additionally, market participants have difficulty getting a lawyer to sign off that something is not a securities offering or does not implicate the securities laws. It's because the lawyers don't know either. So, and then they go on, in this void, litigated and settled commission enforcement actions have become the go to source of guidance. People can study the specifics of token offerings that become the subject of enforcement actions and take clues from particular cases. However, applying those clues to the facts of a completely different token offering does not necessarily produce clear answers. So, what I'll say with this is I think everybody should be pretty filled in on, how did Ethereum come to be? Well, they had a pre-sale ICO before the Ethereum network was even launched in order to kind of fund all those operations. And then the network launched. And we know Bill Hinman said, what would it be? Irregardless of the token offering that occurred, it would seem that Ether has become sufficiently decentralized at this point and would not be a security. So I imagine people that or parties that interacted with the XRP token, including Ripple Labs, took what was said about Ether and were like, well, we didn't do any ICO or any kind of that stuff. So like we must be pretty in the clear. And we know like Coinbase had issues with listing XRP for a while, not knowing if XRP was going to be a security or not. And I'm sure this Ether speech helped them with that. And they, eventually decided to list XRP back in spring of 2019. And then going forward, Roisman and Peirce continue to say providing clear regulatory guideposts and then bringing enforcement actions against the people who ignore them is a better approach than the clue by enforcement approach that we have embraced to date and that today's settlement embodies. And that is referring back to the coin schedule case. And then lastly, in short, we know folks have questions and confusion persists in the marketplace. How do you have fair notice and people understanding regulatory clarity, all that kind of stuff, if confusion continues to persist in the marketplace after 12 years since the first cryptocurrency, decentralized cryptos going live? And then they also say it is important that we start providing clear and timely answers. uh, and I just kind of say, like, huge shout out to Roisman and Hester Peirce for coming out and saying this. I think that takes a lot. I'm sure they're going to get blowback from inside the agency or, any of the prosecutors at the SEC currently going after Ripple or any other possible, crypto related securities case probably isn't going to be too happy with them on this. I always felt like Peirce and Roisman were kind of all talk with nothing to show for it, but this is an action that they took, and I really appreciate that. And to go on here, let's just kind of talk how else the Ripple lawyers use this to kind of address their case. And this last paragraph will kind of cover that. So, after two tries, the SEC failed to adequately plead knowledge or recklessness on the part of the individual defendants. The public statement confirms that charging the individual defendants with an offense that requires knowledge or recklessness was and is legally untenable. Plainly, it could not have been so obvious that the individual defendants must have been aware of it. Years ago, that XRP was an investment contract when two of the five SEC commissioners acknowledged today that the regulatory status of digital assets remains so characterized by a decided lack of clarity that the only certainty we see is that people have questions about how to comply with the applicable laws and regulations. I mean, to me, this whole thing's pretty damning, and I would imagine that maybe we see some movement on Larson and Garlinghouse's motion to dismiss here. I don't know how long it would take, but before not too long. The judge is definitely going to have to address this. And to wrap up with some other updates, so like we were talking about the Hinman deposition, I think it looks like that's going to go through on Thursday, July 27th. Originally, the parties had agreed to do it today, but after the call last week, the judge said that it'd probably be worth everybody's time to kind of figure out what exactly the questions are going to be allowed to be, so that the SEC is just not constantly calling privileged information on everything, and it's not a complete waste of the two parties' time. And additionally, Hinman was classified as a high-ranking official, so he does have privilege over the deliberative process. But to me, one of the questions is if this speech is, something that is his personal feelings, then how much privilege does he have if it doesn't have to do with an official thing from the SEC? To me, if it's personal, then I don't know how much privilege he gets in that regard because it doesn't necessarily have to do with his duties as a high ranking official. But if it is tied in more in that way and privilege should be allowed on some of the questions, then I would also ask, who else was involved in this and why has there been so much waffling from the SEC? Either way, I think there's some great developments here. And, we as ordinary citizens may never get to see everything that comes from this deposition. But if it's damning enough, who knows? Maybe the SEC won't even want it to go forward or, let whatever comes out of it out and it could lead to settlement, or some kind of dropping of the case. That's me hoping, but we'll just have to see what happens in the next couple of weeks. But after a summer of really not much coming here, we're starting to see the case build back up for sure. Um, Sorry that Mickey wasn't able to make it today. He's been kind of wrapped up in some really great deep dive research, and he will have some really cool information to share with everybody here in the coming days. Regarding some big names in the industry, so you guys can look forward to that. And yeah, we'll see you guys in the next one. This is the DeFi Standard, and I am out.